Hey, welcome everybody. Welcome to the Law Self-Defense Show for March 30th, 2020. And we have a very special show indeed. We have with us a criminal defense attorney out of South Dakota, Marshall. Let me take care of that. Marshall Lovrien, if I'm pronouncing it correctly. I'm sure he'll correct me if I'm not. And he had a very successful self-defense case and a first-degree murder trial just in the last few weeks in South Dakota. And he's reached out to me to share the story of that success. And he's agreed to come on the show to speak to all of you to get the insider's view of what it's like to win those kinds of prosecutions. So if you're not interested in this, you are out of your mind. So I'm going to play the little intro video, and then we'll come back with Marshall. So here we go. There we go. Hey, Marshall, how are you? Sorry about this. I'm kind of a monkey operating all this internet streaming stuff. Folks, this is Marshall Lovrien. Am I pronouncing it correctly?
You are.
All right. So I told him you're a criminal defense attorney out of South Dakota, had a successful self-defense trial in a first-degree murder case. Perhaps you could introduce yourself and then share with us your view of the facts of that case.
Absolutely. Thanks, Andrew. So, we had a first-degree murder case up here in Aberdeen, South Dakota. Facts in a nutshell are really this. On the night of January 1st, 2020, our client shot and killed his daughter's ex-boyfriend after the ex-boyfriend came into our client's home in the middle of the night and had threatened to kill our client and his daughter and others who were in the home. The relationship between the daughter and the boyfriend was toxic. That's probably the nicest way to put it. It was marked with abuse. She had broken up with him earlier that evening. He being the boyfriend or ex-boyfriend, had threatened to kill her, came out, was looking for her, again, entered our client's home. Over the course of about 13 minutes, the ex-boyfriend was told to leave repeatedly, did not leave. He was tried to physically escorted out the door, would not leave, continued to encroach closer and closer into our client's residence. And then after about 13 minutes and the gun being drawn and pointed at the ex-boyfriend started to lunge at our client, and our client fired the first shot, which entered the lungs. That was a fatal wound, but not immediately fatal. The decedent then fell to the ground, was reaching for his pocket. Our client thought he had a gun on him, which was he was known to carry guns. He, in fact, had a dagger, 4-inch dagger in his pocket. Our client fired again. That shot was to the neck. Not a superficial wound, but not a fatal wound. Interestingly, in this case, a lot of this activity was captured on a surveillance video. Now, when I say a lot of the activity, most of the 13 minutes was not. It all happened outside the frame of the camera. The first shot was caught on camera, but you do not see what the decedent was doing. All you see was his foot. And again, that's because he's just off the field of the camera. When he falls to the ground, that's clearly visible. The reaching for the pocket's clearly visible. Shortly after that second shot, 911 was called. It takes law enforcement about 18 minutes to respond because this is in the country. It's a winter night. The decedent was pronounced dead almost instantly when law enforcement had arrived. The next day, our client was charged with first-degree murder, a premeditated murder. A little over 2 years later, he went to trial at the end of last month that went into this month. And after about a 4 or 5 day trial and 9 hours of deliberation, the jury acquitted our client of first-degree murder, second-degree murder, first-degree manslaughter, and second-degree manslaughter.
Which were all the charges. So he was acquitted on all charges?
Correct. He was charged only originally with first-degree murder, but in South Dakota, as in many other states, if the law, if there's some evidence of lesser included offenses, then the jury is instructed on those. So the official charging document was first-degree murder, but the jury was instructed to consider the lesser includeds.
Now, is that up to the state or up to you, or is that just automatically happens?
There's a statute in South Dakota that says if there's evidence of those lesser includeds, the jury should be instructed on that. And so it's relatively common in South Dakota.
So if you'd had a choice, would you have preferred not to have the lesser included, just go with first-degree murder? Or
It's always that's the $1,000,000 question, right? Do you ask for the lesser included? Does the jury compromise this in some shape, way, or form? Certainly if there was a conviction of first-degree murder, it's hard to know, right? It's really hard to know. If there had been a conviction of first-degree manslaughter instead of murder, would you say, boy, should we have rolled the dice and gone big or gone, home? Hard to know. It's just really, really hard to know.
And as I understand it, the client was initially, when he was arrested, he was given bail of $1 million.
Correct.
This was later reduced, but that's a sizable sum of money. I guess it was, you mentioned to me before we started, it was reduced to $400,000 later. But even then, you have to come up with $400,000 in collateral, put up 10% that the bail bondsman gets to keep. So that's 40 grand for the privilege of being bailed out. And how long was it? So between the acquittal and the initial event, how long would he have been in jail if he hadn't had the bail money?
January 3rd or so, 2020 to March of 2022. So, 26 months roughly. And there were, of course, some COVID hit, which suspended most of the jury trials, if not all the jury trials in South Dakota. And so thankfully our client was out on bond during that time, but COVID affected us in South Dakota like it did virtually every other jurisdiction in terms of being able to adequately and safely, conduct jury trials.
So, of course, the reason you and I got connected was because apparently you would come across some of my work at Law Self-Defense, and you found it helpful in arguing the defense for your client. And after the fact, you reached out to me and got in touch with me to let me know, which I can't tell you how much I appreciated. But perhaps you could share with our audience how that came about.
Absolutely. So one of the things I would tell any criminal defense attorney watching or listening to this today is self-defense cases are a very unique animal. They're just very, very unique. They're not a drug type case. They're not a sex offense type case. It's one of these weird, you're disproving a negative. And so they're just very, very different. And so, of course, early on, we looked for as much literature, as much written material as we could on self-defense, how you analyze these cases. And of course, one of the first books I found on Amazon was this. I ordered it. And Andrew's exactly correct. He did not solicit me. I sent him an email afterward just thanking him. I dog-eared the pages of this thing to take the different chapters and those elements and then work them into our theory of the case. It was invaluable. It was an invaluable resource. One of the things I would tell practitioners early on, if you're going to do a self-defense case, whether it's deadly force, whether it's the simple bar fight, I'll call it, where it's just, hands, a simple assault, learn about self-defense, learn about the experts, learn about the use of force experts that you may want to consult with and retain, read the books. I will tell you, Andrew, that there were many nights I would be on my iPad looking, watching your podcasts, reading old reviews, reading critiques of cases from George Zimmerman, all the way up through Kyle Rittenhouse, through
That's a lot of
through the Florida movie theater popcorn shooter case. I mean, I was watching these things almost in real time, the analysis. Look, there's no cookie cutter approach to any of these sorts of cases. Facts in every case are different. The law is different from jurisdictions, but I will tell you, your analysis was extremely helpful and extremely critical in our focus of the case. And so what I would tell any defense attorney out there watching is, look at that analysis. Look at Andrew's analysis, his critique, his criticism, his compliments of these various factors, and then work that, massage that into your own set of facts. Just invaluable. I mean, absolutely invaluable to me, working through the 5 chapters, those elements on putting that all together. I mean, just very, very, very critical. So,
well, I can't tell you how much I appreciate that. I mean, I'm largely, people really ought to think of me as an academic lawyer. I don't go to trial anymore, go to court anymore. I haven't for very many years. I'm really doing education for the most part of lay people and attorneys. We do a lot of CLE instruction as well. So to get some affirmation that the information and the knowledge and the analysis we're putting out there is helpful to you guys actually in the trenches, in the arena, winning these fights is extremely humbling and extremely gratifying. So I really appreciate that. And one of the things I always caution all of our members is, please read the book, take our courses, do all that. You'll learn a lot about use of force law. Of course, that does not make you a criminal defense attorney. There's 1,000 things, other things that happen in the course of a criminal defense that can make or break the case all by itself. But what the courses can do for you is at least basically tell you your part. These are where the legal boundaries are for you, so that when you talk with your defense attorney, God forbid the worst happens, you can at least give him good facts. Because if all you can give your attorney is bad facts, it's going to be a very difficult defense. But if you can give your attorney good facts, well, you can make yourself, in effect, hard to convict, because the state does have to disprove that claim of self-defense beyond a reasonable doubt.
Absolutely. And I think that's one of the biggest things that I learned in this process, and one of the biggest things I think is worth stating, is being able to educate jurors. Number one, from the very beginning, that first time you meet with your client, research the law in your jurisdiction as to self-defense, what those elements are. But make sure you're able to educate the jury on who that burden is in proving or disproving self-defense. We, right out of the gate in voir dire, made sure we asked those questions, because that natural inkling is, I use deadly force, but I'm justified in using it, right? Whereas the law, at least in South Dakota, is if self-defense is introduced either by the prosecution or by the defense, then the burden is on the prosecution to disprove beyond a reasonable doubt. And so it's really important to make folks understand that, or help educate them very early on, so they know what to look for, and they know what to be paying attention to.
And they can filter all that testimony and evidence through that threshold. I mean, it drives me crazy when I see lawyers just kind of mention this in passing during closing argument, or maybe even come out with a chart. I always recommend people use, but only during closing argument. It's almost too late by then. By then, the jury's kind of decided whether or not it feels like self-defense or not to them, which is really a preponderance threshold. But I strongly urge lawyers always to do this in voir dire, even before the jury's seated. Get them to emotionally commit, nod their heads, agree that they're going to abide by this threshold that the judge will instruct them on, so that everything they hear and see through the course of the jury, they're thinking, well, is that 90%, 95%, or is it short of that?
Right. And we of course used a chart in closing arguments. We used one very similar to, and I tell people my process in this was, I think I bought every book written on a George Zimmerman trial, some of these what I call high profile cases, to find out what worked, what didn't in there. Certainly Kyle Rittenhouse's trial was last fall, so we were watching that. One of the great things about technology today, as opposed to 10, 15, 20 years ago, is you can really, if you're an attorney, follow some of these what I call high profile cases, because they're streamed online in a lot of these jurisdictions, or follow your analysis, Andrew, and really soak that in. But we used that chart. The other thing I would tell folks is this: don't be afraid, if you're a defense attorney, to use visuals for a jury. For example, in the case that we just tried, the entrance wound there was between ribs 2 and 3, and it exited between ribs 7 and 8. I'm not a biologist. I'm not an anatomist. Between ribs 2 and 3 and 7 and 8 doesn't mean a whole lot to me. Again, the claim was that the decedent was beginning to lunge forward at our client.
And just to explain this for the audience, I know you touched upon it before, but the video evidence of this, the defender is all the way on the left side of the image, and he's facing the aggressor off screen to the left. I think you can see the aggressor's foot, but that's it. You can't actually see the aggressor when the first shot is fired. And then the aggressor kind of falls forward, which would be consistent with lunging, fall forwards into the frame on the left edge of the frame, and you can see him reach for his pocket and all the rest of that.
So one of the things we did was, okay, this is interesting. How do we tease this out? We went and bought a science lab type skeleton, one you would expect to see in a high school biology room or a college class. And we literally took a wooden dowel and had the medical examiner run that dowel through ribs 7 and 8 to 2 and 3 to kind of show us the trajectory. And when I say show us, show the jury the trajectory,
the angle relative to the body.
Exactly. Yeah. And so if that body was standing upright, it was a very, very pronounced trajectory, and of course you can see the light bulbs kind of clicking on for the jury that he probably wasn't standing straight up. He must have been bent forward or leaned forward in a slight position, consistent with what the defendant had said. And so We thought that was very helpful. We thought, that certainly animates the theory of the defense much more visually and much more easy to understand than simply saying, well, exit or entrance wound is between ribs 2 and 3, and exit wound is between ribs 7 and 8. So don't be afraid to do that if you're a defense attorney. Don't be afraid to use those charts. Illustrate for the jury the standard beyond a reasonable doubt, and then disproving that, working your way down for the state to disprove that or the prosecution to disprove that as it relates to self-defense. Those are very, very important factors. The other thing I would tell criminal defense lawyers is this: along with watching and subscribing to podcasts and blogs like yours, Andrew, other resources, the National Association of Criminal Defense Lawyers, a very great group out there that have wonderful CLEs on self-defense, sorts of things to argue to the jury, how you do jury selection. Again, these are very different cases. Self-defense cases, as we know, are not whodunit cases, right? Identity is generally not an issue. It's a matter of, yes, I did what the state.
It's the opposite of the normal criminal case, right? The normal criminal case is I didn't do it. It wasn't me. I have an alibi.
Right.
I did do it. I shot that guy.
Absolutely. And so it's really important and critical to be able to, articulate for the jury who the appropriate burden is early on, all the way through trial and up through closing arguments. Look, you're not going to win a case in closing if you haven't done the work up to that point. Okay. Closing may win it for you, but you've got to do the appropriate groundwork on the front end. And so when you're taking on these sorts of cases, absolutely look at other cases in your jurisdiction, other national cases, what I call the high profile cases, and just analyze them. What was done right in those? What would you have done differently? Again, facts are always different, but it's really important to get a kind of a broad cross section of some of these other cases and how attorneys have approached those and how those facts or how those elements may fit into yours.
And we cover a lot of high profile cases, of course, and often the attorneys are doing pretty much a good job, but almost invariably there are areas of weakness, right? The opening wasn't great, or the closing wasn't great, or maybe they were great on cross, but there were other areas where they were kind of weak. So you can really benefit just from studying those as case examples, like, airline pilots learn from other pilots' crashes, and take those lessons home to make sure we don't repeat those mistakes as well. Another reason I'm really grateful that you're here is in many of these high profile cases that I cover, there's often a political factor involved in the case. And sometimes, like in the Rittenhouse case, it appears that the prosecutor's politically motivated, really working around the edges of what I would consider ethical for a prosecutor. But that's not normally the case. Most prosecutors are just good civil servants trying to do a good job for their constituents. I presume that was the case in this trial. It wasn't that the prosecutor was acting with malice in any respect. He simply thought he had a case that needed to be put before a jury.
Absolutely. And I think that's absolutely true. I mean, the prosecutors in this case were more than competent prosecutors. They're good prosecutors. They're frankly good people. They're doing their job. And when we have cases like this, that's why we have a jury system. A jury decides those. They're the judges of the facts. They're going to listen to the evidence that's presented to them, and they're going to make a decision on that. And so these were very competent prosecutors. They prosecuted a very competent case. As I tell folks all the time, cases can go either way. If a prosecutor or a defense attorney are telling you this is a slam dunk, we've got this in the bag, I would be concerned, because that's very rare. It happens, but these cases can go either way. And when they can go either way, that's all the more reason when you're a defense attorney to make sure you're leaving no stone unturned. You are understanding the facts of your own case inside and out. You're analyzing those facts and kind of the elements that I'll call them. With other cases, again, it doesn't matter what happened in this case or that case. You're going to have 12 independent jurors in your own case who are going to look at this differently. And juries, do strange things. I mean, they just absolutely do. And I don't mean that in a bad way, but, it's so you've got to know your facts. You've got to know the elements. You've got to understand self-defense. You've got to understand the use of force. You've got to understand means, opportunity, jeopardy. You've got to understand innocence. You've got to understand imminence. You've got to understand those things and how they play.
For folks who don't know, those are the 5 elements of self-defense that we talk about all the time. But it's also important for people to understand. I mean, as we say, the prosecutors in this particular case were professionals acting without any malice in particular towards the defendant, but they were in it to win, right? They wanted that conviction. And if they had won, your client would be spending the rest of his life in prison, I imagine, without possibility of early release.
Right. Yeah. In South Dakota, first-degree murder is a mandatory of life in prison and a minimum of life in prison. In certain cases in South Dakota, first-degree murder is punishable by death. And so it is very, very, the consequences are very, very severe. We talked a little bit about kind of from the defense attorney standpoint, how you would approach this and what, the things that we learned and tips that we're happy to share. But the other thing I would tell folks who aren't lawyers, right? You watch Andrew, you listen to Andrew, you're just interested in self-defense, you've got a gun or a firearm for self-defense. We know how easy it is, all things considered, to get a firearm, right? I mean, you don't have to have a PhD to get a firearm. You don't have to have a PhD to fire a firearm or use a firearm. It's more difficult to get a driver's license and be licensed to drive than it really is to get a firearm. And so what I would tell folks is, if you're going to have a firearm for self-defense protection, make sure you take as much training as you can to understand the law, to understand the mechanics and all of these sorts of things, because the consequences can be very severe, very, very severe if you find yourself in this situation. Obviously, you could be charged criminally. You could be deprived of your liberty. You could be convicted at trial. You could be financially bankrupt going through that process. We think of all the training that law enforcement receives on when to use that firearm. Well, that's appropriate that they receive that level of training. Look into joining self-defense type organizations that may be able to provide financial help to you if you find yourself charged criminally. Remember, firing the gun is the last thing anybody wants to do. We always want to find a way to de-escalate that situation before deadly force is used. But it's very easy to get a firearm. It's very easy to use a firearm. Just make sure that if you want to use that tool, totally appropriate, totally perfect tool, legal tool to use, you do the training, take advantage of as much training as you can get so that when you're in that situation, you know what to do. Because if you think about it, if you ever find yourself in that situation, you're going to have to make a decision in a split second, right? Split second decision, your life or somebody else's life. That prosecutor, that investigator, they're going to have hundreds of millions of seconds to go back and analyze that split second decision that you made. And so,
and of course, they don't know what actually happened, right? All they can do is look at the evidence and even you don't know what happened. I would argue in many cases, the defendant doesn't know what actually happened in any absolute sense, given the stress of the event. I mean, they often can't remember how many shots they fired and things along those lines. Certainly the jury doesn't know what happened. It's not like they were there when it went down. They didn't witness anything. So they're just hearing stories, right? They're hearing the story from the prosecution about guilt, and they're hearing the story about you from the defense attorney about their client's innocence. And at the end of the day, they have to make a judgment call. That's their duty imposed by the court. But it's never absolute. I mean, they're not required to come to a verdict, absolute certainty of guilt. It's guilt beyond a reasonable doubt.
Absolutely. And so, again, people's lives can change in a heartbeat. And if you're the one firing that gun, certainly somebody's life is going to change, right? Potentially two people. You've either fatally wounded somebody or you've seriously wounded them. And then, of course, you may be charged criminally as well. So a number of lives get affected by a split-second decision. And that's where that training is so critical, because just like CPR, if you've all of a sudden got to do CPR on a family member or a friend, you don't have time to think about the mechanics of that. You do the training, you get it ingrained in you. So when that happens, you just by rote memory almost know what to do. Yeah. Same situation here.
It's too late to get to training once you're getting your ass beat in the parking lot. I mean, then it's over. Right. Now, you mentioned all the resources you turn to, not just my materials, but other materials as well, which is fantastic. I mean, it drives me crazy when lawyers don't do that. I think they owe that as a duty to their client. Unfortunately, you probably have met criminal defense attorneys like this too, but some of them are out there and just basically, all their clients are criminals and they just kind of crank the handle and do the same, go through the motions the same way every time. But few of them put in the kind of effort that you're describing that you put into this case. And I always caution people, you can't assume that someone knows this stuff, use of force law, at that kind of level, simply because they're a lawyer, simply because they have that job title. If they've made the effort, they certainly can. I don't know about your experience, but in my 3 years of law school, we spent maybe 5 minutes talking about use of force law, first year criminal law. I wasn't really taught this stuff in law school at all. What's your experience in that regard?
Yeah, absolutely. I mean, it is, again, it's a different animal. It's a different animal just because of the upside down nature of a self-defense case. And we see laws changing nationwide around self-defense. I mean, interestingly, as this case was pending, the South Dakota legislature, and I don't think it was because of this case, I just want to be clear on that, our legislature last year adopted a new statutory scheme on immunity. Self-defense immunity, very similar to the statutes in place in Florida. Our legislature passed that, our governor signed that, so there are stronger protections, I'll call them now, for those folks exercising self-defense rights.
And I understand they're making immunity even stronger effective next year.
Correct. Yeah. So that law passed last year in our legislative session. It took effect July 1st of last year. This legislative session, which just wrapped up, they modified, they being the legislature modified that to provide that if you're claiming immunity from prosecution, then the burden is on the state to prove by clear and convincing evidence that you did not act in self-defense. Last year, when this statutory scheme was passed, it was silent as to that burden. So then, there was some litigation, if you will. Well, who's got the burden? Is the burden on the prosecution? Is the burden on the defendant? What is that standard? And so the legislature tweaked, fixed, modified, however you want to say that, so that we've got some clarity. Everybody's got clarity. The courts have clarity. Defense bar has clarity. The prosecution has clarity.
And by the way, that almost perfectly mirrors what happened in Florida, too. They passed self-defense immunity as a statute, but the statute didn't say anything about who had the burden or to what threshold of evidence. So the courts kind of defaulted to, well, the burden's on the pleading party by, a preponderance of the evidence. And Florida found that nobody was being granted immunity for all practical purposes. So the legislature stepped in and said, no, we're making it clear now. We're putting the burden on the state to disprove self-defense by clear and convincing evidence at that immunity hearing, which of course is what will go into effect in South Dakota next year.
Right.
Or this year, I guess.
Yep. July 1st of this year is when it takes effect. But it's again what I would tell any practicing attorney watching, listening, if you're going to be doing this line of work, when I say this line of work, we're talking self-defense work. This is just as important on your shelf as Lefebvre's Criminal Law and Procedure, as a Black's Law Dictionary, as a medical atlas, so you can reference things. It was very succinctly put together. Literally, I took the chapters apart and then I put those elements, applied them to our facts to work and massage our theory of the case. So again, in my opinion, and again, Andrew didn't solicit this from me, right? This is just me talking. If you're doing this kind of work as a criminal defense lawyer, you would be very wise to spend the money and have this on your shelf. You're doing your clients a huge disservice, in my opinion, if you're not working through those elements, because you've got to be able to articulate for a jury those facets of self-defense. Even though the burden's on the prosecution, right? You've got to be able to articulate imminence, opportunity, means, jeopardy, those sorts of proportionality, those sorts of things, so that a jury understands that. The reasonable person standard, objective, subjective, all of those elements come into play. And you've got to, if you as an attorney don't understand those, how can you expect a jury to? And if we don't expect a jury to understand them, what are the chances that your client is acquitted or gets a favorable result?
Right. I mean, they know your client shot somebody, right?
Correct.
And maybe killed them. And in my experience, juries want to know, hey, listen, maybe there was a good reason for that, but we need to hear that good reason.
Absolutely. Yeah. And so you've got, as a criminal defense lawyer, you have got to understand that. Not only, again, you got to understand the facts of your case, every single fact, heights, weights, differences, all these things, but then how those individual factors lay out when it comes into arguing self-defense and articulating that for a jury.
Hey, Marshall, that was my timer going off. So Marshall has a court appearance in just a few minutes, believe it or not, folks. He graciously gave us time to come on the show, even though he has a court appearance he has to run off to. I promised him we wouldn't go past half the hour. So And here we are. So, Marshall, thank you so much for sharing this experience with you. Thank you for your kind words. It's
You bet.
extremely humbling. And I look forward to staying in touch in the future.
Thanks, Andrew. Thanks, everybody.
All right, folks. So I'm going to stay on a few minutes longer, go through the super chats and see what kind of questions we have. Hey, Steve Gosney, I see that you're here. Steve, maybe I'll, let's see if I can do this. I'll send you an invite. And how will I send it to you? Let me see. If you care to join, Steve, what's the best way to do that? In the meantime, I'll be happy to answer any kind of questions that are posted as super chats. So if you'd like a question answered, post it as a super chat, and we'll go through all of these. Steve, what's the best way to reach you? Just drop it in the comments. I know we had an issue with email. Let's see. Well, I'll try to I'll try to send it to your I'll call it your presidential email address. So here's the link. If you care to jump in, just check your email, and hopefully you'll have received that, and you can jump in if you like. All right. Well, that was just an amazing story. I actually I got to see the relevant video of that event over the weekend. I was at the tactical conference, Tom Givens and Lynn Givens tactical conference this past weekend. Whoops. No, here's Steve. Okay. Try it again, Steve. I got an email from Steve. I'm replying with the link. So it looks like Steve will join us if he can. And it looks like Marshall didn't turn off his camera, but only I can see it, so that's fine. So, yeah, I appreciate that. I know you can kind of see my my second. That's actually it's fine. There's nothing currently on my monitor I need to worry about. I guess I'll have to fix that picture behind me. Put some kind of anti-reflective glass on that picture of Washington crossing the Delaware. Yes, I did some trimming of the beard. Our trimmer came in. Well, I gotta. Oh, I guess Steve is bending over there. Okay. Hey, Steve.
How are you?
You misspelled your name there, Steve.
I know.
Tev.
The absent-minded professor here.
I can edit it here.
Where's this thing? Here it is.
I got it. All right, Steve. Welcome. So that was Marshall Lovrien with his success in this South Dakota self-defense trial. This past weekend, I got to see a bunch of the video from that trial. I didn't want to share it here because, in my experience, although the client allowed Marshall to come on and talk about the case, so there's no issue of client confidentiality there. But it's normally the case that people who've been through this experience and then get acquitted, they don't want their name to be high profile. They just want to get on with their lives, and there's nothing's added to the story by getting specific about names and things like that, or sharing the video. It's not that important. So what did you think, Steve?
Wow, what a great attorney! You've got a network of Braca fan followers, right? That's really neat. In fact, boy, that fellow is a very good trial attorney. You can tell just by the way he speaks, the way he presents himself, the way he analyzes things, the amount of dedication that watching your videos.
And how conscientious he was, right? How dedicated it was, how much work he did for that client. Because I can assure you, folks, there's plenty of criminal defense attorneys who don't do that. They accept the client, they take the retainer, they apply whatever knowledge they happen to have on board at the time, and that's the defense you get. They don't go doing hours and hours and hours and hours. By the way, theoretically billable hours. that probably aren't being paid for to do all the stuff that Marshall did. I mean, it's really remarkable.
Well, and you really can't pay for that type of dedication. You know, that is an attorney who cares. And, you know, that's somebody's heart who's in there, who believes in their case, believes in their client. And that's a very ephemeral quality that I don't think that you get with, it doesn't matter if you pay somebody $100,000 or you get a public defender. It's sort of a quality of just a great defense attorney generally. And I don't know. I mean, I know that, well, you had John Terhune on here a while back, and he's somebody like that. We have a lot of people like that in our public defender's office. So, but he exhibits that. You know, that's where you can get a quality attorney, and I think that's, if you're looking for a defense attorney, that's the quality you really want.
The trouble for most people, of course, is for a normal person, they don't really know how to tell. I mean, I run into this all the time. People say, "Hey, Andrew, how can I find a good attorney if ever it should happen that I need one?" And I always tell them, listen, the best thing I can tell you to do, I mean, listen, if you want to call me, it's a use of force case, and I can recommend somebody, I'm happy to do that. And I do that without any kind of referral fees or anything from the other attorney. But absent that, the best you can do is really educate yourself. I mean, spend $8.95 for shipping and handling, get a copy of my book for free, read that. At least you're somewhat of an informed consumer. You have some sense of what questions to ask and what kind of answers to expect, because if you don't know that, you just get rolled. I mean, any attorney is going to sound like a genius compared to you because you know nothing.
Right. It's hard. People ask me all the time about finding lawyers and how do you decide. And, you know, even like, I know who a lot of the good attorneys are in our office. I know who the best attorneys are. Right. I mean, I know who they are because I talk to them, I train them, we discuss things from the trials, and I've seen them in action. And I know some of the best attorneys within our jurisdiction and who the bad ones are, but it's very hard. If I was a consumer, boy, I don't know. That's a tough thing to find. You know, like I said, you've got a network going here with your people that are propagating throughout the United States with your book.
Yeah, I had long thought about putting together a list of attorneys who've been vetted in some respect, but it's so difficult to do the vetting in a way that I would consider, you know, appropriate and responsible to the end user. I mean, so many of these things are intangibles.
Right.
And I can tell you folks, by the way, if you have some kind of many of these so-called self-defense insurance programs that have a whole list of lawyers, often those lawyers are on the list. They don't even know they're on the list. I know I'm on a lot of lists. No one asked me. Presumably I know what I'm talking about, but I have to tell you, I don't take clients. So I would not be lead counsel on a case. There's too many. By having a very narrow, deep, but very narrow focus, I've taken myself off the table. I don't have that broad set of skills anymore to be lead counsel on trial. So they put me on their list, and I get calls, people wanted me to represent them from out of state, from everywhere. I never knew I was on that list, and if they had asked me, I would have told them not to put me on the list. Well,
there's even technology that generates these lists sort of automatically. I mean, like, I get things all the time soliciting me for, and I don't pay for my clients don't pay me. I mean, I'm a public defender, so we're free, right? And yet they're wanting me to promote myself, and then they put you on these lists, and they're generated by the computer. So, I mean, actually, I think probably, if I was to recommend somebody how to hire an attorney, I would definitely find somebody like yourself who doesn't have a stake or a something in the game, who knows the legal landscape to refer you. That'd probably be my first choice, right? So if you have somebody in the area that you know who's a lawyer who knows the makeup, who would you recommend, right? And who would you not, maybe?
Yeah, so of course we have our platinum membership here at Law Self Defense. It's part of how we provide consulting services to our members. And for those members, if they're involved in an event and they retain an attorney or considering retaining an attorney and would like me to talk with that attorney, I'm glad to chat with the attorney and then give them my opinion. Nothing's with certainty, but at least I can give them a sense of whether it sounds to me like the person is someone they would want to bet the rest of their life on. But if I did that for everybody, I'd be doing nothing but having free conversations with criminal defense.
Let me ask you: would you when you do that in the platinum membership, do you tap into your network? Because I know that you know people all across the country.
The first thing I do is look to people who may be in in that jurisdiction that would be available to provide, because those people I know personally, those people I've had conversations with beforehand, long before the event. So they're not trying to, con me so they can get a job in the particular moment, get a retainer in the particular moment. I've seen them working over a long period of time. So that would be my first choice to recommend. And usually when people talk to those attorneys, they want them because those guys actually know what they're talking about, and it shows.
Excellent.
One thing I wanted to mention to people, just as an aside, and this is not, I want to make clear that Steve is not promoting this, because
I don't promote anything. I got to find something to promote,
Yeah. You should do that, man. That would be a good move. We have a bunch of whoops, that's not what I wanted to do at all. All right, let me try this. So many buttons. Let's see. Oh, good heavens. There we go. So we've put, as most of the audience probably knows, a couple of times a year, we do a full day law self-defense course. We stream it online over Zoom to everyone who's registered to attend. We do charge for that course, but we've decided to put together a series of webinars, 1 hour to 2 hour webinars. We have a whole bunch of them scheduled, 8 or 10 of them scheduled over the next couple of months. And these are 100% free. So if any of you would like to sign up for those, when you go to that link here, lawselfdefense.com/hard-to-convict, you'll be able to pick from various dates on which one you prefer. The only caveat is we are limiting each one to 100 people. So if there's a date you'd like, I would encourage you to sign up sooner rather than later. And again, it's 100% free, folks. So if you're interested in a couple of hours of myth busting on self-defense law and how dangerous those myths are and how to not get taken by them, you may want to consider that. One of the reasons I wanted to post this was I heard some people were having trouble with the link. So if you try it and it doesn't work for you, just let me know in the comments and I'll get my IT people on it.
Let me ask you, because I've heard that talking about myths of self-defense, one of the things we always run into is, of course, people want to tell their side of the story to the police officers at the event. And obviously, we as defense attorneys always say, I want my lawyer. I wish to remain silent. I'd like to have my lawyer. Would you recommend, in the event of a concealed weapons use or a use of a firearm in some self-defense scenario, would you ever go beyond that?
So it's a more complicated question than it seems. So there's I think of really kind of 3 approaches to this, interacting with the police in the aftermath of a use of force event. And actually, it's quite a bit more complicated than people imagine, because there's multiple different interactions you have with the police. There's 911, there's the responding officers, there's the investigators. And I think you really have to treat each of those differently. But in general, there's 3 approaches that people might consider. And one is the say nothing approach, which is what you just said. I'm not saying anything until I have a chance to consult with my attorney. That's definitely one way to go. And if you're an actual criminal, that's definitely the way you want to go. Nothing good is going to happen to you from talking to the police. It's a little more subtle when we're talking about a law-abiding person involved in the use of force event. They're not normally a criminal. Then on the other extreme, you have just blathering the whole story, every detail of what happened to the police. That's definitely a bad idea, even if you are a law-abiding person, because you don't know what happened. Your recollection of what happened is imperfect, to say the least. And you could very well end up saying things that are inconsistent with witness statements or surveillance camera footage, or just you don't know the words that you might say that could be used against you in court. You just don't know, because this is not what you do. You do real estate, or you're a doctor, or whatever the case might be, but you're not a criminal defense attorney. And by the way, criminal defense attorneys shouldn't be, hopefully they would remember not to blather away either. There is a middle ground that I talk about. I used to recommend is too strong a word, but I was probably more positive about it in the past than I am in the last few years. And I call it, instead of the say nothing approach, the say little approach. And basically what we suggested to people was, identify yourself, give them your name. If you're talking to 911, give them your location or whatever the relevant location. I mean, you're calling 911, so resources will be sent someplace, right? Otherwise, what's the point of calling? So give them a location. And by the way, this is stuff they're going to know anyway, right? They're going to know your name, unless you're just planning on running away. And then perhaps more controversially, if there's exculpatory evidence or exculpatory witnesses, identify those to the responding officers. So if the bad guy had a knife, came at you with a knife, and that's why you shot him, and the knife slid under a car and may not be in clear sight, you want that knife recovered. That's why you shot the guy. If there were witnesses, generally speaking, for good guy cases of self-defense, we want more evidence is good for us for the most part. So you want those witnesses identified. So otherwise they're lost forever. The reason I'm more hesitant about this approach is maybe 6 or 7 years ago, one of the big self-defense simulator companies loaned me a self-defense simulator, a giant Pelican case I could bring to my live classes, and I would teach law for 8 hours. And then we would set up the simulator. We'd have people engage a simulated video threat that they'd have to solve that problem with a fake infrared pistol, and then explain to the class afterwards, well, what they saw in the video, what they did, and the rationale for what they did, the legal rationale based on what they'd learned in class. And this is an entirely artificial environment. It's a video. There's no way for people to get hurt. But the stress they experienced going through that simulator, they couldn't recall what they saw or what they did or rationally explain it after the fact. Their hands were shaking, their voice was shaking, and often they would recite things that didn't happen, or they would recite them in the wrong sequence. And this is based on a video that lasted 30 seconds, 60 seconds. And so I began to realize that, man, the stress that people would experience under an actual life-threatening attack, and then expecting them to be cool-headed enough to do that say little thing without starting to blather may well be an unreasonable expectation. And I never tell people what to do. I just offer options and encourage them to think about it ahead of time. And, I don't know people as well as they know themselves. So they have to make the ultimate call on what they're prepared to do. Certainly blather, absolutely bad.
Blather is bad advice, right?
Yeah, talking to the actual investigators without a lawyer, don't ever do that. There's no upside to that at all. What you might say to police on the scene just to make sure exculpatory evidence is captured, I'd like my clients to have that exculpatory evidence. But if that's going to open the door to blather because that's your personality type, that would be a bad thing. And it's amazing how the variety of ways that people get in trouble. I mean, I worked on one case where a guy was involved in a use of force event. He shot somebody, and it pretty much looked like a solid case of self-defense. But immediately after he'd called 911, he got on his phone. So his girlfriend actually called 911. So the 911 line is still open. And this guy, the shooter, calls his dad and says, "Dad, you won't believe it. It happened again."
Oh.
He'd been involved in a previous self-defense shooting that he'd been cleared on. But now when the prosecutor in the second case said, all right, this is the second time this guy's had to shoot someone, something smells bad. He ended up getting prosecuted. Whereas if that had never been recorded, the prosecutor may never have known that that prior event had occurred.
Well, look, I'll add to this because obviously I always say do not talk to anybody. Yeah. And 911 calls routinely get admitted as an excited utterance. Yep. So you're going to get the 911 calls going to come in, but
only if it's bad for you.
And that's the warning, of course, is it will be used against you because what happens is people think, oh, I've got this stuff that I said to the cops. I want to bring it in my case in chief. You can't bring that in the case in chief because it's only used against you. But another thing is that when people invoke their rights and then they get arrested, then they think that a defense attorney is going to come parachuting into their jail cell or in the interrogation room. And that does not happen. What happens is they're arrested, they go to jail, and then they sit in the jail cell till the next first appearance, which is usually 24 hours. At first appearance, they just talk about bond.
Right.
And then you might have 2 weeks for your arraignment. And at the arraignment, you might talk to a defense attorney. Now, if you hire private, you can get them a little quicker. But people think that there's defense attorneys waiting in the wings to parachute down. So when they request the defense attorney, all of a sudden they magically appear. And when that doesn't happen, then they think, well, wait a second, I'm going to talk my way out of this. And then they waive. And they say, let me tell you what happened. And then all the statements come out, and then defense attorneys left with that bag. So there's an expectation question here, too, that people don't think beyond the initial, I didn't say anything, but then they're shocked when the attorney doesn't show up immediately.
Yeah. And when for folks who don't know, when waiving your rights doesn't mean you have to announce, I'm waiving my rights. If you're Mirandized and you just start talking, you've waived your rights unless you reassert them. And I often have people ask me, "Hey, what's an attorney can you recommend an attorney?" And they're not in need of an attorney now. They just want a number in their wallet in case something happens 5 or 10 or 15 or 20 or never years down the road. And first of all, as a matter of policy, I don't do that because frankly, some of those people start calling that lawyer and it's not billable time for the lawyer. It's just a waste of his time because the person doesn't actually need legal representation yet and doesn't want to spend any money. But also, is something, when are you going to need them? 10 years from now? In 10 years, I might recommend a different attorney to you rather than that guy. Second of all, it's not like that attorney's waiting in a glass capsule, break in case of emergency. You're going to call that number and he's going to come running to your aid. He's working all day. He sleeps at night. He's got other stuff going on than waiting for a call that likely is never going to happen. So absolutely. The notion that now, occasionally it happens, but that should not be a reasonable expectation for anybody that the lawyer is going to be immediately on site.
The best that you can usually do is get a lawyer at your first appearance. And in fact, smart lawyers around here, they bail people out before their first appearance so that that way they don't get additional conditions imposed at first appearance. I don't know if you're familiar with that whole issue. We deal with that all the time.
Yeah.
And it's like they impose these conditions, which I don't really think are constitutional because of the bearing of the burden of proof. They're presumed innocent, but that's a whole nother bag. But if you're smart, you can bail out immediately on the police bond. But usually shootings and firearm cases are no bond cases if you're actually charged with something really serious.
Hey, Steve, it just occurred to me that, of course, I know who you are, and much of our audience knows who you are, but maybe not everyone watching this knows who you are. Could you give us like a 10-second, who are you?
I'm an assistant public defender. I do criminal appeals in 5th District Court of Appeals in Florida, which is Orlando and Melbourne and Daytona Beach and St. Johns County and 11 county area. So, and I've done state appeals, argued for the Florida Supreme Court. I've done a couple death cases and actually done some cert petitions, U.S. Supreme Court. So I just do criminal appellate law. Generally.
All right. Just so people have some context around your comments.
I guess I could promote my SSRN page, which is what I always end up doing, which doesn't help anything. But it gets me more rankings for the academic ranking thing.
Feel free, Steve. If you got a link,
I don't know. It's basically I write academic articles too, which I like to promote because academics, it's funny because I'm not an academic, I'm just a practitioner, right? But I write all these law review articles that I really write for practitioners because, I always get these questions from people, from lawyers and it's like, well, that's a good question. And I start thinking about it and then I start writing and then I write into this huge essay to analyze whatever the question is. So
yeah, and I can't tell you, it's almost hard for me to express to people how important it is that someone like you, an actual practitioner, is writing law review articles. Because folks, a lot of law review articles, I would say most of the ones I've read, at least in my area of expertise, are garbage. Yes. They're written by law students who don't know anything. They're just doing it so they're on law review or whatever the case might be. They're written by law professors who are not practitioners. So it's what they're suggesting is completely academic and removed from reality. So to have someone who's actually there doing the work, write a law reviewed article that may have practical implication is absolutely huge.
Right. Well, I'll double down on that because so much academic writing is just garbage. I mean, it's useless to the practitioner. It's all this political correctness, and gender theory applied to stuff. And we have to go to training. We do trainings, and I guess I'm a controversial guy, so what can I say? But I go to these trainings and they talk about all the racial disparities in criminal justice. And I think you'd be betraying your client if you did some of those motions that they recommend at these educational seminars, because it's just like you're arguing these big, colossal, universal, change the world in your case, when your job is to represent that client and get the best result for that client. I'm not going to be muddying up their case with some racial disparity motion. I mean, unless there is, it could be a case where it is, but very rarely, you got to be specific. Well, your guest here was excellent. He talked about your book, and your book is an essential component, but getting a lawyer who can take those ideas and translate them into the facts that you have and really know the facts of your case and how that self-defense law and the facts interact, that is essential.
Yeah, it's almost like what I talk about in my book is kind of the fundamental ingredients, folks. It's the ingredients you need to make the dish, but someone's got to know how to cook that. And that's at least in part art and experience and conscientiousness and a lot of other factors that go into play. All right, so we're pushing up to the top of the hour. So let me step through some of these super chats so I don't keep you too long and we don't keep me too long. And let's see, the first here, Susan, Saran Concord, thank you for your super chat contribution, asks debate in chat, but we'll answer it. Maybe you already answered this, Steve. If you do not have lesser included, so only the top level charge, and you're found not guilty of the top level charge, can you face another trial on the lesser charges? You want to take that one, Steve?
Yeah, I did answer that. Basically, the answer is no. That's called double jeopardy. So if you have a charge, if you're charged with first degree murder and there's a lesser, say, manslaughter, then and you're found you're found not guilty, just flat out not guilty, then they cannot retry you on the manslaughter. Now, some people had mentioned in the chat about federal jurisdiction, okay, and there is concurrent federal jurisdiction. It's called a separate sovereign doctrine, and I don't agree with this, but I actually had a case on it, and case just came out in Florida, at least, that they can try you separately under federal law, but there has to be a federal statute, there has to be a federal interest, and in my experience, it is extremely rare. It's probably a lot more common in the cases you cover, Andrew, because you're covering these high-profile political cases.
If there's a racial disparity, then you get the civil rights angle, denial of civil rights. Yeah, especially a police shooting. Obviously, then it's an automatic. Really, if a cop's involved, it's an automatic Section 1983 action.
But I will tell you, I mean, I was a prosecutor for 6 years, and I've been in the public defender's office now for about 12 years. And I think I must have handled 7,000 cases, and and of that, I've had one where the feds took it over.
Yeah.
So, no, I'll take that back. I had an appeal just about 2 years ago where somebody had been prosecuted, and they then got prosecuted a second time by the feds. And it was the other way around. No, he got prosecuted by the feds, and then the state prosecuted him, right? And I was trying to argue that the federal case precluded the state case, and he actually got 10 more years in the state case. And the answer to that was no, separate sovereigns. They were able to prosecute him twice. But that's only 2 cases in probably 7,000 cases I've had. So very, very rare.
Yeah, and this is how hard it is, folks. Is you look at cases, high-profile cases like George Zimmerman, the feds crawled all over that case, and they never tried to prosecute him. The Michael Brown hands up, don't shoot case, the feds climbed all over that one too. I mean, trust me, they're looking for a hook, and they can't find one. So the prospects of now, often what they'll do is they're going through the motions of the investigation on the federal level for political purposes. So there's some federal politician, often the president, who says, "Oh, we will, and don't worry, that person was acquitted in state court. There's still hope for us getting justice. We'll do it at the federal level." And then 2 years of investigation later, nothing comes of it. And it's that investigation, I assume, is unpleasant for the prospective target, but very rarely do they actually end up in federal court. Let's see, Daryl Conger. Thank you for your super chat, Daryl. Says, got your book. It's incredibly well written and easy to understand. Well, thank you very much, Daryl. A copy should be sold along with every firearm or other weapon. Believe me, Daryl, I've been trying to convince the gun companies to do that for ages. If I was printing the book in that volume, it would be pennies in addition, and I'd be happy to make it available at virtually no cost to the gun companies. We give the book away for free as it is. In fact, if you're interested in that, I can pull this up real quick. Let's see. There it is. You can get the book for free. I mean, we do ask you that you pay the cost of shipping the book to you, and our warehouse guys got to pay their mortgages. But I think it's $8 or $9 shipping and handling. The $25 cost of the book we eat right there at lawselfdefense.com/free book. And if we were printing books at the volume that guns are being sold, the book would essentially cost us pennies to provide. But so far, no gun manufacturer has taken us up on the offer. So I appreciate the thought. It's been our thought too, but so far, no luck. Joseph DiMartino writes, as a CCW Safe member, CCW Safe, by the way, is one of the sponsors of our content. Let me pull that up as well, since they were brought into the conversation. See, Steve, the grift never ends. This is
The grift never. Well, actually, I got hard. You know.
all right. So CCW Safe, they're a sponsor of our content, much of our content. They provide legal service memberships, what many people mistakenly call self-defense insurance. In effect, they promise to pay their members legal expenses if the member is involved in a use of force event. And they actually provide a lot more than just money. They provide an in-house investigative team. Many of the members are retired homicide detectives, very experienced. They have attorney Don West, their national trial counsel, excellent criminal defense attorney. So anyone interested in that kind of coverage, I would encourage you to take a look at what they have to offer at lawofselfdefense.com/CCWSafe. And if you do decide to become a member, you can save 10% off the first year of your membership with the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10. So, Joseph, it said, as a CCW Safe member, I'm guessing any attorney they refer will have been vetted by someone. If, God forbid, I'm involved in a self-defense case. In the case of CCW Safe, I can tell you that is the case. So their national trial counsel, Don West, does, well, first of all, they have a list of pre-vetted attorneys. So they would recommend one of those. If you had a different attorney you would want, they would also vet that attorney. And let me tell you, if Don West suggests to you that the attorney you like is not a good fit for this case, I would suggest you're taking a heck of a risk by not listening to that advice. But yes, you would get that vetting. Not all of these self-defense insurance companies do vetting. Some of them, in fact, I was doing quite a bit of partnership with one a few years ago that I'll leave unnamed. And I asked them how they vetted their recommended list of attorneys. And they said, well, we call the bar and make sure they're in good standing with the bar. First of all, I know that wasn't true because I saw at least one attorney on their list who was not in good standing with the bar. To my personal knowledge, they'd been suspended from practice. But even that, folks, I hate to say it, but you got to work pretty hard not to be in good standing with the bar. I mean, unless you're taking client money
that's a low bar. That's
a pretty low bar.
No, Don West too. He the one that he did the Zimmerman case.
He did, yeah.
O'Mara, and those two. That's one of the best. You did some great coverage on that. That was one of the best. I'd say defense trial attorney performances that I've just ever seen in any public case was Don West and Mark O'Mara. And here, right over, actually, that's within my jurisdiction that I appeal. And we were very happy that they won because then I didn't have to do the appeal.
It was, I really think it was about as close to a perfect legal defense as you can get. And I know Mark was interviewed afterwards and he says, yeah, we got an acquittal. We should have gotten an acquittal. I mean, there was no evidence inconsistent with self-defense. And I agree with that assessment, but it could have gone bad. I mean, the risk of conviction is never zero.
Right. Well, I'd even say even a good case in defense, even a good trial is 50-50 because you never know what kind of baggage jurors bring into the courtroom with them and what they do or do not disclose. I had I think I sent you some stuff on a lady who does jury investigations. She's done about 55 cases where she's investigated jurors, and she has found juror misconduct in every case she's investigated. I mean, that's pretty frightening.
It is. By the way, folks, Steve sent me the link to his, I call them law review papers here, his academic papers. So if you look through the comments, you ought to see that link appear there, posted by me.
What was it? O'Mara, and we always get happy when people win at the trial level because that's one less appeal we have to do.
Yeah, that was a fantastic, really an eye-opening trial to watch.
Well, sure. And the prevalence and I'd say the addition of these political trials is really a disturbing trend. The political prosecutions we're seeing with like the January 6th people, and I think the Zimmerman case was one. A lot of it has racial overtones or political overtones. That should really play no part in political prosecution. Generally, should not be political. But sadly, it is. That's like the state of the world we're living in. You see a lot of those things. And
yeah,
I don't know whether it's the media or what, but
it's terrible. And it's kind of I mean, the modern world finds itself in between a rock and a hard place because of this kind of historical artifact where we give prosecutors enormous discretion in deciding what cases to bring. And frankly, I think they largely need that discretion. I mean, cases are complicated. There's a lot of judgment calls that go into it. And if you have a professional, ethical, trustworthy prosecutor, you can trust them with that kind of power. But
Well,
you don't know if that's who you're going to get. And increasingly, these prosecutorial seats are effectively being purchased. I mean, most
well,
of
and
these
it
seats,
goes both ways, because I mean, I know that a lot of our conservative friends say that, well, these Soros prosecutors don't prosecute things, but there's the other side too, and there's the people that prosecute everybody to the max.
yeah,
And so you don't know what jurisdiction you're in. Your prosecutors are, and that's another thing. You really need to have your defense attorney on board, because the political prosecution is very bad. Either way it goes. If you've got somebody who just wants to hammer everybody, not everybody deserves the death penalty. Of course, here's the defense attorney hat going on.
or the punishment of the process.
No, right. And we deal with this. How can you defend the guilty? And I always like to bring up the case I had a while back on appeal. Lady got 19 years in prison for stealing a can of spray paint from Walmart.
Yeah,
I
remarkable.
was like, well, she's guilty. How can I defend that?
Yeah. I always just tell people, I'm not really defending the client. I'm defending the Constitution.
Right.
Because if whatever client it is, if they're not privileged to have a capable, a competent legal defense, then nobody is effectively. And then we live in a gulag nation, and I don't think you will like that one little bit.
Well, and it's also part of an adversarial process. The defense team is part of what you've got: the judge, you've got the prosecutor, you've got the defense team, and you've got the jury. And each one has to perform its role. Like when a defense attorney isn't doing their job, they're not performing their role. They're not advocating for their client properly, right? If you've got a prosecutor who is advocating for guilt rather than looking to seek the truth, that prosecutor is not doing their job. Same thing with a judge. If a judge is putting their thumb on the justice, they are not performing the system. The system is what we say generates the justice.
Right.
And if one of those parts isn't performing in accordance with their role, then the justice system is not functioning properly.
Yeah, I often tell people, especially when I cover these cases, these highly politicized cases where people are picking sides like crazy. I don't particularly care about the outcome per se. I certainly don't care about the defendant per se. I mean, they're not a friend of mine. They're not a family member. I'm not personally affected if they go to prison or are acquitted, but I care a great deal about the process.
Right.
Because the process affects all of us.
Exactly.
All right, here's another super chat, a little bit outside the norm, and it asks about various scientific things. And I will say, of course, I don't claim any scientific expertise here. For a small town lawyer, I have a surprising amount of scientific education. So I did my graduate work in various biology related fields at Harvard long ago, in epidemiology, virology, immunology, molecular biology. So I have a really excessive, for my actual job, excessive education in science. So with that as context, Mark Sermon asks, as far as I can understand, things like blood spatter analysis, polygraphs, hair analysis, bullet analysis is all woo-woo pseudoscience. Thoughts? Well, not all of it is woo-woo science. I mean, a lot of it is good science, but misunderstood, like DNA analysis. Often people present DNA analysis like, well, if you didn't find the DNA, the person must not have been there. That's not the case. People are places all the time without leaving DNA. So the absence of DNA is not much evidence. If DNA is found, you can have a high probability that whoever that belongs to was at that scene at some point to leave the DNA. A lot of these other areas, like bullet matching, blood spatter, bite patterns, none of that has been proven to anything like we would require, say, of a pharmaceutical product going through FDA approval. It's just things that really non-scientists looked at. It felt good to them. They got it somehow accepted by the courts, and the rest of us are all supposed to believe that that's actual science.
Well,
most of it's not.
You actually have you are scratching one of my erogenous zones when it comes to appeals. This is the fallacy of scientific bullet testing. That is a complete and utter faux science. Now, an FDA, well, we use FDLE, Florida Department of Law Enforcement, but the examiners can say, okay, we recovered a bullet, and this bullet is consistent with a .357 Magnum. The .357 Magnum revolver was recovered off the defendant, and this bullet is consistent with being fired from that, right? I mean, that's That's completely legitimate.
Sure.
But when they say this bullet
gun
was
fired this
by
bullet,
this bullet, that is complete garbage. But it gets in evidence all the time.
Yeah.
And the FDLE will testify to that. And I have argued that on appeal over and over again, but it's got to be argued at the trial level. And if anybody's interested in, I don't know, this was a question in the lake, right? There's a great article on the firearm bullet matching controversy, and it's called Hypothesis Testing. I brought it up here. Hypothesis Testing of the Critical Underlying Premise of Discernible Uniqueness in Firearms Toolmark Forensic Practice. That's the title of the article. It's a mouthful. And it's by a fellow named Tubin and Blau. Tubin, Tobin, and Blau, Blau. And that article is the definitive article that destroys this idea of bullets matching a particular firearm. And it goes through every reason that that's not valid science. But it happens anyway, and it goes in unobjected to. The defense attorney doesn't even know that that's an issue. And
how many attorneys have any kind of science education? I mean, really, they became attorneys because they didn't like science and math.
Right. Or what they need to do is challenge that under something called Daubert. And I've done this with our trial division a lot. But yes, that's and you say, well, polygraphs are generally not admissible, so we don't see a lot of polygraph stuff. But
unfortunately, a lot of stuff can get a Daubert-like cloak. I mean, when you ask the Daubert, has it been published? Do other experts agree? Well, who are the other experts? I mean, everyone doing bullet analysis is going to, reinforce that bullet analysis is effective, and they all publish on it. So it can look like it's science. It can have that appearance, but it's never actually been rigorously tested in a scientific way. I mean, things like bullet matching, you can. If it's used to exclude stuff, that's fine. If the bullet has 6 lands and grooves and the weapon has 7 lands and grooves. I mean, obviously the bullet didn't come out of that gun. But it's when they reach too far in the positive direction.
This is a match to the, and just as a quick, why is this false? Somebody asked, well, how can that be? Because they do not have a database. Let's say there's 1 million Glock 9s out there, not 9mm out there. They don't have a database of the barrel grooving of those 1 million Glocks. So how can you say, well, we've got this one and it's consistent, it matches? Well, do you have a database of the other 1 million Glocks out there? No, there is no such database. So how can they say that every other Glock is excluded from firing that? That's just fake science because there's no such database.
Right.
But they think
millions of Glocks, just take the 9mm, take all the Glock 17s. Did you fire a bullet out of all of them and they're all really unique to the eye of an examiner? I don't believe it. Well, I've seen a lot of fired bullets.
Right. Well, one of my, I've got lots of crazy ideas. I'm too creative for my own good. But one of them is I'd love to send to FDLE like 10 bullets and 10 matching Glocks. And say, now you match up each bullet to each Glock and have an independent accounting firm do that. But they'll never submit to that because they're getting it in anyway.
Right. And a fair test would not be 10 anyway. It would be like 1,000.
Well, statistically, I bet you could do it with 10. I don't know. I'd have to consult my stat, but you do it in some statistically meaningful way, right? If they were able to match every one up, then I'm a believer. Now that's scientific, right?
Right. And not just once. Have like 10 examiners.
Have a regular testing of the lab, but they don't do that. Why don't they do that? Because they know they couldn't do it.
Right.
Yeah.
Yep. Absolutely, for sure. So yeah, I look at a lot of these magic CSI type forensics examination things as just largely
now
either inherently nonsense or nonsense in the way they're applied in the court.
DNA is pretty good, but people always forget that how is that DNA placed on that item? Because the DNA is there doesn't conclude guilt. There's no magic CSI machine. That's the thing. It's a human, trials are a human exercise.
And that's assuming the humans are doing everything perfectly. I mean, we had a forensics department in Massachusetts while I was still living there, where basically the woman in charge of the department, something went wrong in their head, and she was just making stuff up. And they had thousands of criminal convictions they had to redo because all the lab results were nonsense.
Well, which is all the more reason for them to cover it up. Boy, lots of stories. Let's just say I don't have much trust in the system at this point. I doubt everything because there's so much corruption and people want to hide their vulnerabilities. They want to seem like they know things. And Socrates was asked he was asked, well, you're the smartest guy in all of Athens. And he's like, how can that be? I don't know anything. He's like, yeah, because everybody else was faking it.
All right, Steve. Well, I think I'm going to wrap things up. Thanks for coming on, Steve. I really appreciate it. You're welcome anytime.
Nice seeing
and of
you.
course, it was great hearing from Marshall. I can't tell him again how much I appreciate his taking the time to do this. Good criminal defense attorneys don't have a lot of free time, folks. I really appreciate
Great to see him. What a great attorney he is.
Yeah, absolutely. All right, folks. So in closing, I just remind all of you that if you carry a gun so you're hard to kill. Okay, let me get rid of Steve here. There we go. All right. Before we go, let me mention once again these webinars, because I know they're going to fill up fast. So I just want to make sure all of you get a chance to attend one of these free webinars, 100% free webinar, folks. They'll be probably no more than 2 hours in length, but about 2 hours. We have a series of dates set up. If you go to that website, you'll that link, lawofselfdefense.com/hard to convict. You'll see the list of dates for our upcoming hard to convict webinars. Just sign up. They are limited to 100 people for each one. So I encourage you to sign up sooner rather than later so you don't get locked out of those dates. I don't know how to make it less expensive than free, folks. So if you're interested in learning how the most common myths of self-defense law are busted by us in those webinars, and how they're not just wrong, these myths, but they're dangerous to your liberty, sign up at lawofselfdefense.com/hard to convict. And as for the rest, remember, if you carry a gun so you're hard to kill, please keep in mind it's also important to know the law so you're hard to convict. Until next time, I remain Attorney Andrew Branca, the bearded version for Law of Self-Defense. Stay safe.